Issues with service charges are systematic, widespread and persistent, according to the Social Action Housing Campaign, which has compiled a dossier detailing exorbitant and unjust fees. Are you being overcharged? And if so, what can you do about it? I'm Daniel Barnett, a barrister based in central London, and I'm also the presenter of the Legal Hour on LBC Radio. In this video, I'll explain what service charges are considered reasonable, when you can take your landlord to tribunal to challenge those service charges, and alternative methods of dispute resolution. Leasehold charges usually include fees for services like maintenance, repairs, cleaning, and caretaking within common areas of the property, and for the upkeep of the building itself. Your landlord, either themselves or through a property management company, can recoup your share of these costs through regular charges and also ad hoc one-off bills. As a leaseholder, it's within your rights, set out in the Landlord and Tenant Act 1985, to ask for paperwork detailing the breakdown of any service charges that you are asked to pay. If you don't think you're responsible for the charges, or you don't think they reflect the quality or quantity of the work carried out, the first thing to do is contact your landlord or the managing agent and say so. If their response is unsatisfactory, you've got four options. One is to take your freeholder landlord to a first-tier tribunal. That's allowed even if your lease appears to forbid you from doing so. You can opt for arbitration or mediation, or you can seek what's called a neutral evaluation. Even during a dispute, it's usually best to pay any service charges that are due if you're able. If you win at tribunal, you'll get them back. If you lose, well, you avoid problems such as having the charges added to your mortgage payments. Applications to first-tier tribunals cost £100, and if a full hearing is needed where you attend and present your case, you'll have to pay another £200. You might be eligible for help with these costs if you're on a low income or if you're receiving certain benefits. Now, at the tribunal, an independent panel will listen to both you and the freeholder and make a decision on whether the service charges are reasonable or not, based on the evidence that you both provide. On the panel, there will usually be a lawyer, a valuer and a layperson. That's someone without any specialist knowledge of the subject. They have to abide by what are called overriding principles, which include reducing formality where possible and helping to keep the process accessible to everyone involved. Although tribunals are more informal than courts, you should be aware your landlord may well arrive with legal representation. Now, this can seem intimidating. It could increase your costs if you were to lose the case, because you might have to cover some or all of your landlord's professional fees. You are also allowed to have someone speak on your behalf. That can be a lawyer, or it can simply be a friend who you think would handle the situation well. But it's also possible to represent yourself. Either way, you should prepare your case thoroughly, and it should be based on facts rather than just feelings. Just because you feel something's unfair doesn't mean that it is. So how do you know which service charges are reasonable, and how do you know which aren't? The first thing to do is read your lease carefully. The freeholder can only claim service costs from you for things specified in the lease. If your service charges stray outside the scope of your lease, you'll have a valid case. Next, think about the reasonableness of the charges themselves. Unreasonable is a difficult word to define, but some of the things that the tribunals will consider are whether the work, including the extent of the work, was necessary, whether it was done to an appropriate standard, how your landlord continued to provide services for you while the work was undertaken, whether the cost of the work was fair, often the most important question, how your landlord managed to control the cost of the project, and what amount was it reasonable for them to pass on to you. That's given the length of your tenancy, given the amount of the property you occupy. You might be able to garner support from neighbours in the same property who agree that the service charges are unfair. If so, work together. Work together to collect evidence and present your case. Now, as well as collating any relevant documentation from the work carried out, it can help to see what other professionals think. For example, you could ask other contractors for quotes for the work. That'll help you establish whether your landlord is paying above market rate. So, as an example, the tenants in the case of Forcelux and Sweetman discovered that there were far cheaper insurance policies than the ones they were being asked to pay the premiums for by their landlord. The tribunal determined a two-stage test that should be followed to decide the case. First, The freeholder, the landlord, has to prove they acted appropriately when setting the costs to pass on to the tenants. Second, the resulting costs don't have to be the cheapest option, but they should be reasonable. They shouldn't be excessive. So the landlord has a duty to make sure the charges are reasonably competitive. In this case, the landlord argued that the quotes found by the tenants weren't comparable to the premiums obtained by the landlord because there were additional benefits to them being underwritten by one policy. But in the very similar case of COS Services against Nicholson, the tenants were able to find suitably like-for-like policies that were a quarter of the price of the premiums that COS Services had asked them to pay. It was ruled therefore that the landlord costs were excessive and so weren't reasonably incurred. It's also wise, by the way, to obtain advice before committing to a tribunal and to help you prepare for one. Doesn't have to cost anything. You can book a free 15-minute phone consultation with the Leasehold advisory service on their website or consult Citizens Advice. Links for both of these organisations are in the show notes below. Instead of going down the tribunal route, you could consider quicker and cheaper alternatives like arbitration, mediation, or early neutral evaluation. You and the freeholder both have to agree to the process. Now, some leases specify that service charge disputes go to arbitration, but it's an option even if yours doesn't. You and the freeholder can agree on a single arbitrator. You can choose one each, or you can opt for a more extensive panel, including a chairman and an umpire. Their ruling will be binding, assuming you've agreed to that being binding. Fees vary depending on the number of people engaged and the length and complexity of the case, and you may end up having to foot the whole bill if you lose. Mediation avoids the risk of incurring your landlord's legal costs. Normally, it takes place in an informal setting where both sides air their grievances and hopefully come to an amicable solution. A mediator will be in the room to keep things on track, to help you focus on the issues and to help you communicate effectively. You can find an appropriate mediator on the Civil Mediation website, which again is linked to in the show notes below. Early neutral evaluation sees an independent expert, assess your case. You can choose an appropriate evaluator from a list of professional bodies, again linked below. Costs are split between you and the landlord and they start from about £200 to £300 an hour. Now, while an evaluator's decision isn't binding, meaning neither you nor the landlord are obliged to follow their recommendations, it gives you a good idea of what a tribunal is likely to decide. If you found this video useful, please do give it a like and subscribe to the channel, and here you'll find more information on landlord and tenant rights. I'm Barrister Daniel Barnett. Thank you so much for watching. Bye bye.